any teen porn, Daisy.
Robert Kraychik here reporting for Rebel News in Ottawa, Ontario at the conclusion of day 22 of the Tamara Lich and Barber trial. Both are being charged with crimes linked to their roles as organizers in the 2022 Freedom Convoy, a peaceful demonstration against what I call the COVID-19 enterprise, this series of mandates, decrees, edicts, censorship, and other forms of coercive controls ostensibly issued by our governments for the purposes of public health. Today's proceedings were primarily dedicated to dealings with an ongoing disclosure dispute in which the two defense teams are seeking full revelation, full disclosure of a series of documents that the Crown says should be protected, redacted, censored, kept from the defense for different reasons. We got to speak with Eric Granger, one of the defense attorneys for Tamara Lich. He explained to us some of what's going on. We also got to speak with Adam, a lawyer that we know who's with the Democracy Fund. Before we get to that, however, I want to remind you folks that we need your support to continue our operations. So please go to tamaratrial.com to contribute if you can, and also to stay up to date with all of our coverage from this trial. In your own experience, have you ever seen a situation where solicitor-client privilege was invoked in a communication that did not directly involve a lawyer?
Well, as we were talking about in court today, everybody seemed to agree it's a very unique situation that obviously if any of us had seen this situation before, you'd have heard of it in court. So I think it's fair to say that nobody in the courtroom has dealt with this particular scenario before.
And last question, just in terms of the general knowledge of the evidence being sought to be fully disclosed, what has become publicly known in the trial from Friday to today in terms of what this entails? We know that it's an email chain. We've got some things related to the so-called wiping of these police officers' work phones. What can you tell us about the evidence itself in terms of what's known about it?
Yeah, so in terms of what we've heard in court, we've heard that there's a series of 4 documents. One of them we've heard specifically relates potentially to this wiping of a phone, some sort of 5-page document that's described as a standard operating procedure of some sort of the Ottawa Police, that those 5 pages have been redacted in their entirety. 3 others are emails, again seemingly from what's been said in court, related to disclosure from these PLT officers, communications between police officers in relation to disclosure from the PLT officers, including requirements from May of last year, communications several months after things ended, but long ago, directing PLT members to produce things such as emails and text messages and voicemails and various communications that they had in the context of a lengthy list of individuals, names that we've heard associated with the events in Ottawa, and including our 2 clients in this case.
So I'm here with Adam from the Democracy Fund, who's been in the courtroom all day. He's actually been here for some time now. Adam, let's talk about today's disclosure dispute. So why don't you tell the audience what the claims are that are being made by the prosecution to justify their position that information being sought by the defense counsels should be redacted or protected or kept from the trial?
Okay, yeah. So there's 2 lanes here. There's one lane where for the 5-page fully redacted document where the Crown is claiming that is subject to a third-party record. That means it's not in their hands. It is not a as opposed to a first-party record, which is in their hands. With respect to the heavily redacted emails that we spoke about on Friday, these are what the Crown is claiming there is that there are relevance issues with some of the paragraphs, solicitor-client privilege issues with others, and then litigation privilege cited on others. And what are those things? Well, solicitor-client privilege is privilege between, it's in the name, between a solicitor and a client. And typically those arise when a solicitor and client are engaged in confidential communication. So this is a little bit strange because From what we saw, all of the case law that was provided by Ms. Stewart, who is the representative of the Ottawa police chief, none of the jurisprudence that she cited, the case law that she cited, they all included a Crown and officers, or a solicitor and officers. The problem with that is the case at bar, the Lich and Barber case, the redactions that were made involved two officers. So where is the solicitor in this solicitor and client relationship? That seemed to be a point that Perkins McVeigh was pushing back on while Ms. Stewart was making her submissions, and we didn't really get to the bottom of it. Perkins McVeigh said she won't be in a position next week to make a decision on that because it seems to be a bit of a novel issue.
Okay, let me interrupt you for a second. I want you to take out your phone and show me what you showed me a moment ago. You were looking at a Supreme Court decision that set the parameters, in broad terms, defining what types of communications are protected under solicitor-client privilege. In other words, attorney-client privilege, lawyer-client privilege, privileged legal communications between a lawyer and his or her client.
Right.
So you had that bullet point. Why don't you share that with us?
Right. So it's the direct quote is solicitor-client privilege exists where 1, it is made in confidence, with 2, a professional legal advisor, and 3, for the purpose of giving and receiving legal advice. And again, just sort of to reiterate, the issue that we've got here is the legal advisor is not present. So they may have the other 2 rungs, but how do they make it out on that 3rd rung, which is that a solicitor is present, and this communication is strictly for receiving, providing and receiving legal advice?
Yeah, just to make it clear for the audience, the defense teams are seeking full disclosure of communications between police officers. So police officers talking to police officers does not include a lawyer or a solicitor. So how does solicitor-client privilege apply? Well, we'll find out. So one other thing. We talked about litigation privilege. Can you tell our audience what that means and how that may be germane to this trial?
Sure. So litigation privilege typically comes up where there is an ongoing litigation matter that is not the case at bar. Mm-hmm. So in this context, what the Crown is claiming with respect to litigation privilege is that all of the communications that have been redacted for litigation privilege are subject to an ongoing other litigation. We don't know, it hasn't been made clear what that other ongoing litigation is, but I believe it's in part why Ms. Stewart was here to make submissions on that. She'll be replying, I think, to some of the responses given by the defense tomorrow, but we'll have to wait and see what she says tomorrow.
Based on what they said towards the end of the day, we can expect that this issue particularly will be wrapped up somewhere tomorrow afternoon. Vanessa Stewart, who is a lawyer with the Ottawa Police Service, was present in the courtroom during today's proceedings. She was there to provide the Ottawa Police Service's legal rationale to support the Crown's claim that its redactions on some of these documents being sought by the defense teams for full disclosure should be restricted and should be kept from the defense. One last interesting observation from today's proceedings that I want to share with you folks out there is a series of questions asked by the judge regarding this ongoing disclosure dispute. She asked at one point, this is a quote, "I'm still trying to figure out how the police are a client." What does she mean by that statement? She was wondering aloud how communications between police officers are protected by solicitor-client privilege. In other words, attorney-client privilege, lawyer-client privilege. This is a claim being made by the Crown to justify ongoing redactions of certain documents being sought by both defense teams for full disclosure. So the judge is saying, if the emails are only between police officers, where's the lawyer? Where's the legal counsel, the legal advice that is protected? This question of the judge was also asked when dealing with Vanessa Stewart. Vanessa Stewart is a lawyer with the Ottawa Police Service. She was in the courtroom today to share the Ottawa Police Service's legal positioning and rationale for maintaining these redactions on these documents being sought by the 2 defense teams. And the judge asked Vanessa how these documents can be protected by solicitor-client privilege and how it applies to police emails, to which Vanessa Stewart replied that since these police officers were supposedly discussing legal advice and directions that they had received from the Crown, that it's therefore implicitly protected. One last thing the judge said also gave, I think, some insight into how she's making calculations over this ongoing disclosure dispute. She said she finds it odd that two police officers with the Ottawa Police Service, with the police liaison teams, that's the PLTs, these are teams that deal with stakeholders and special events. In this context, they are police officers that dealt directly with Freedom Convoy organizers, including Chris Barber. And again, the judge says she found it odd that two police officers said that their work phones were wiped as a function of some sort of software or system update or upgrade, and that this was an unusual circumstance. So these issues will be determined, we assume, by tomorrow afternoon. We'll have some resolution from the judge. Now, lastly, I'll tell you what the judge can do. Here are the possible options. The judge may decide that she doesn't want to review these documents in question and simply wants to defer to the prosecution's claim that these redactions should be kept. She can also side with the defense and say, you know what, I don't want to see the documents, but I want them fully disclosed and shared in the trial at the defense's discretion. She can also take three other options. All of them involve reviewing the documents herself. If she reviews the documents, she can say, I want a little bit redacted, but not all of it redacted. She can also review the documents and call for total redaction to be maintained. And she can also review the documents and say, you know what, I want total disclosure of these documents. So these are the five potential outcomes that we might see at the conclusion of this disclosure dispute, which we assume to be tomorrow. If you folks out there in the audience value and appreciate this in-the-field reporting that we're doing, please understand that we cannot do it for free. We need your support to continue doing this valuable journalism. Please visit tamaratrial.com to contribute and also to stay up to date with our ongoing coverage.